Alright, I'm going to try this a second time. This is a duplicate of the recording that we were supposed to do a live broadcast of about half an hour ago. Unfortunately, due to some technical issues, I'm going to try this again here. So, again, I'm David Slonim of Slonim and Lemieux. We're an elder law firm that handles probate, guardianship, estate planning, Medicaid planning, and digital asset management. And so what I'd like to talk about today a little bit is common misconceptions that I've come across over a number of years with various people coming to me with some of their things that they've heard about throughout dealing with people and talking about estate planning, and then they come back to me and they say, well, are these things true or not? So the first one that I'd like to cover is whether or not the government is going to get your stuff if you don't leave a will. So first I wanted to cover what a will is. And a will is typically going to be a instruction manual for probate. And so in the probate process, there's either intestate, meaning no will, or having a will, which is testate. And so if an estate is intestate, then there's a thought, I suppose, that if you don't say who's going to get your things, the government's just going to take it. And unfortunately, I suppose, that is not the case. The government doesn't want your stuff, and they're just going to put it aside, essentially, for many, many years before it will actually be collected by the state. And so the state usually has something like Florida does, which is a treasure hunt website where essentially you can just type in a person's name and then see if there's any assets, usually cash, that's left behind by an estate. And so that's what the state is going to do, if anything. But until that occurs, then it's going to be available for a person to file a probate administration for that individual, or you, for example. When you pass away, then even a creditor can file a probate administration to collect any assets that you may have there or distribute them. But it's just not going to go back to the state. It'll just stay in your estate until such time as it would escheat to the state, but that's quite a few years out. Another misconception that I hear a lot is that if you don't pay your bills, then somebody's going to take your house. This normally relates to Homestead Protection in Florida, and in that case, typically your home is protected so long as you do file for homestead, and that is your only homestead. So you can only have one, and you can't file for homestead in one state if you have property there in another state, and in Florida as well. So usually this comes up when we're dealing with potential nursing homes or other creditors that have a claim against the estate, and your home is protected. Under most circumstances, there are some exceptions to that rule. For example, your bank has a mortgage on the house, or some homeowners association or condo association liens that can be filed against the home, or some mechanics liens, but that's really about it. Most creditors don't have access to get your home in that case there. So I wouldn't worry too much about that. Another misconception that I get a fair amount is that your heirs will have to pay your debts when you pass away. And in Florida, again, your heirs do not, are not responsible for your debts if that is the case, if you have some. Even a personal representative doing an estate administration is not personally responsible. However, creditors can still file a claim against the estate, and if there are creditor accessible assets in the estate, then they maybe do that. But first, creditors have to file a statement of claim against the estate, and that is one of the reasons we do probate is to have that notice of creditor period, and that's a 90-day period. If creditors file outside of that period, then they are barred usually from filing a proper claim, and that would be stricken down. So your heirs, again, are not responsible for any debts that you may have. And so if bill collectors were to be calling, then that's an appropriate event, and they should be told as such. So there's nothing that, in Florida at least, your heirs are going to have to be dealing with in that respect. Next, another common myth and misconception is a revocable trust being a good liability protection tool. So some people think about putting a second property like a rental home or something else into a trust. And a trust is a good estate planning tool for certain circumstances. For example, if you have real estate in another state and you reside in Florida, that's a good reason to have that other property in the trust. But again, that's not a liability protection tool. It doesn't protect you from being sued if somebody has a fall or something else on that property. So don't use it as such. There's other tools that are going to be available if that is going to be necessary to do. Protection of the rental property. So again, a trust is not a good liability protection tool. It's a reasonable estate planning tool for the right circumstances. So I wouldn't just rely on that necessarily. And overall, trusts are good these days, not as much for federal estate tax purposes. And years ago, people used revocable trust and other trust tools as a estate tax protection. But in Florida, we don't have any state estate tax, and the federal estate tax as of this year, is $22 million for a couple and about $11 million for an individual. So unless your assets are in excess of that, then there's really not going to be any federal estate tax that we're going to have to be concerned about per se. So a revocable trust is good for other reasons, such as periodic distributions, but that's really going to be something you need to talk to your estate planning professional to figure out if a trust is going to be good. But it's just not good as a rental protection tool, for example. Finally, another good misconception that I hear a lot is that putting your child or family member on a bank account or on a deed for a piece of property is a good idea. And it's generally not, because people do this for some estate planning purposes, sometimes kind of do-it-yourself probate prevention. But the problem is that, for example, if you add your child to your real estate, being your primary home, for example, your homestead, then what you're doing is you're gifting half the property, half the value of that property to that individual. And so if we're doing some Medicaid planning later on, within the 5-year period, then that's going to be a problem because you're potentially going to be creating that as a gift. And for probate purposes, then that is going to lose the benefit of the step up in basis of your homestead to your heirs. And so whoever would receive that homestead through an order determining homestead would potentially lose the benefit of the step up in basis if it was there. And of course, creditors filing against your child or loved one who may be on the deed or bank account have no limitation. There's no bright line in there that's going to say that it's going to be half theirs and don't have access to your property. It's all going to be available. So there are other ways of dealing with that by having a beneficiary designation on the bank account, for example, or an enhanced life estate deed in Florida is also a reasonable method of transferring property if you want to limit the probate situation on that. And there's, again, a good reason to talk to an estate planning professional or elder law attorney to figure out what's going to be the best method for you to get that addressed. So Another way to be able to deal with a bank account, for example, is to have a durable power of attorney. If you're concerned about if you're incapacitated and needing somebody to pay bills and do other things, then being able to have a power of attorney in place to allow your agent, being your child or other loved one or friend, whoever you want to name, to be your agent to pay the bills and do those things while you're incapacitated. That's a great way to do that. Creates a firewall there that again prevents any creditors from going after them with your assets. And then you can have that beneficiary designation on the account, and that's going to transfer right away after a person passes away there. So that's kind of the way that I'd recommend going and addressing some of these misconceptions that I've seen. Now, again, if there's other questions that you may have, feel free to email us or post questions on any of the media that this is posted on, and we'll be happy to review and address those questions as best as we can to the degree that we can. And hopefully we'll be able to do this on a weekly basis. And if you have an interest in this, feel free to subscribe to the YouTube channel, and you'll see the updates there. Otherwise, this will be posted hopefully on Facebook and Instagram and other social media platforms for that. So this is a fun little event, and so I hope that you got some good information out of it, and we'll be reaching out again and doing another post next week, all things being equal. Be well out there, and have a great rest of the day and weekend.